All right, let us call this hearing to order. This is the first meeting of the Senate Judiciary Committee Subcommittee on the Courts, and I am very grateful to my friend Senator Kennedy of Louisiana for acting as ranking member on this committee, and look forward to lively proceedings in this committee during this Congress. We have some terrific witnesses, and I'll introduce them briefly before we present our opening statements. We have Lisa Graves, who is the president of the board at the Center for Media and Democracy. Ms. Graves previously served as Deputy Assistant Attorney General at the U.S. Department of Justice's Office of Legal Policy in the Clinton administration, where I also served. As the Deputy Chief of the Article III Judges Division for the U.S. Courts, and as Chief Counsel for Nominations on this Senate Judiciary Committee for Chairman Leahy when he was serving as chair and ranking member. So she is a familiar presence to us in this room. We will then hear from Michael Klarman, who is a professor of law at Harvard Law School, who writes extensively about constitutional law, government, voting, and of course, the Supreme Court, our topic for today. Ben Jealous is a civil rights leader and the president of People for the American Way. He's a visiting scholar at the Annenberg School for Communication at the University of Pennsylvania and a former visiting professor at Princeton University. He was the youngest ever national leader of the Naacp when he served as president and CEO from 2008 until 2013. And he also formerly was managing editor of the oldest Black community newspaper in Mississippi. Scott Walter is the president of the Capital Research Center. He was previously executive director and a senior fellow at the Beckett Fund for Religious Liberty. And before that was a special assistant to President George W. Bush on domestic policy. He is a senior editor has been a senior editor at the American Enterprise Institute. And our final witness is Jonathan Adler, the Johann Verhey Memorial Professor of Law and director of the Coleman P. Burke Center for Environmental Law at the Case Western Reserve University School of Law. Professor Adler is a fellow at the Property and Environmental Research Center and has worked at the Competitive Enterprise Institute. He is the author of his 2016 book, Business and the Roberts Court. I'll recognize myself for an opening statement, followed by Senator Kennedy for his opening statement, and then we will proceed with the statements of the witnesses, which I urge them to keep well within the 7-minute limit that we have. I will be policing and enforcing that with the enthusiastic support of all the members of the subcommittee on that point. And then we will go forward with our questions. As the chair, I will be here through the entire proceeding, so I will reserve my questions until the end to let my colleagues move forward. We are here because our great American republic is enmired in dark money. Huge gouts of anonymized money by covert political influence. The deluge of dark money pours in through donations in the hundreds of thousands, in the millions, even in the tens of millions of dollars. An entire new political infrastructure has been set up in our country to manage the dark money cascade and to hide the donors. It is a multi-$100 million covert operation, and it has unleashed in our republic more than $1 billion spent in political dark money, resulting in what has been called a tsunami of slime. For a long while, this slime machinery was mostly Republican, but in recent years, Democratic dark money has caught up. Now, Republican colleagues have faced massive attacks leveled through Democratic front groups. So perhaps this slime machine can be a bipartisan concern. The focus of the series of hearings we begin today is on the encroachment of the dark money machinery into the judicial branch of government. This first hearing will provide an overview of various avenues of dark money influence. We will dig into each separately in hearings to come. It begins with the selection of judges. A private organization has long sought influence over judicial nominations to be the good housekeeping seal of approval for conservative judges. But when President Trump formalized this gatekeeper role, things turned toxic. First, a private entity obtained controlling influence over judicial nominations to our country's courts. That alone ought to be a problem. Second, the private organization was completely non-transparent in deploying its influence. It was all covert. That's another problem. Third, the private organization accepted massive, contemporaneous, anonymous donations. That's the worst problem of it all. It looks like the gatekeeping function of this private organization was sold or licensed to anonymous bidders, giving huge interests willing to write huge checks a hidden hand of control at the judicial nominations turnstile. Related groups sprang up in coordination with the gatekeeper group, which the Washington Post has reported combined into a $250 million dark money network out to control judicial selection. We don't know who the big donors are behind this clandestine operation or what business they have before the judges they helped into their robes. It appears that the last 3 Supreme Court justices and many Court of Appeals judges were ushered onto the bench through this operation, so it is no small thing. Once a Supreme Court candidate gets through the nominations turnstile, step 2 is to run political campaigns for the nominee's confirmation. For the last 3 nominees, this was done by an organization with massive amounts of anonymous dark money. In each confirmation, 1 or 2 multi-million-dollar anonymous contributions funded the advertising campaigns. There's no reason to rule out that the same donor made all these contributions, meaning someone, from hiding, spent over $50 million to influence the makeup of the Supreme Court. We don't know who they are, and we don't know what business they've had before the court. We do know that the gatekeeper organization and the campaign organization share the same floor of the same building. All the evidence is that this is the same covert operation. In fact, when the leader of the court capture network left his home at the gatekeeper organization to go wage voter suppression, it was the leader of the campaign organization who assumed his leadership role within that network. With justices thus selected and ushered onto the bench, the dark money task, step 3, becomes how to tell them what to do. Private back channels would lose the justices their jobs, so an industry has emerged to hide in plain view the special interest signaling. Dozens of anonymously funded legal organizations have sprung up. Sometimes they go out and find a plaintiff to produce a case, to bring to the court, to solicit the outcome they seek. Sometimes they form up in choral groups of amici curiae to signal the donor's wishes to the court. Again, all of this is covert, funded in secrecy. What evidence we have shows that parties to cases have funded amici in their own case without telling the court, that flotillas of amici funded by the same groups appear without disclosing to the court their affiliation, and that planners and funders of the scheme discuss, quote, orchestration of amicus briefs and private memos. Usually in cases of interest to this operation, the amici flotilla numbers about a dozen. But in a case before the court right now, one of essential interest to the dark money operation, nearly 50 dark money amici have appeared. Nothing says that the funders of this dark money amicus fleet are not also the funders at the nominations turnstile and the funders behind the judicial confirmation political campaigns. There are many questions to answer about who is behind this scheme and how it interconnects and what the reward is for spending such vast sums. But there's no question about one thing. This machinery is operating right now in all 3 of these avenues. We know that. I understand how politically charged this is, but I submit that if the labels were removed, if this were described as a fact pattern in a law school exam, no one would contest that something is wrong here. No private organization should control the turnstile for a country's judicial nominations. Worse, they should not control the turnstile without transparency. They should certainly not be accepting massive donations while controlling the turnstile. And they should not hide the identities of the massive donors buying spots at the turnstile. If we have to have confirmation advertising campaigns, they should not be paid for by anonymous big donors. And no one with business before the court should be engaged in any of this mischief. Courtrooms ought to be open places where you know who is present, not a place where powerful players can come masked behind front groups, hiding both their own identity and their interconnections. The Supreme Court should not be a place that has a special interest controlled fast lane, bringing certain special interest chosen cases before the court at high speed without the trappings of a real case or controversy. The court itself should not tolerate this. But if it won't respond, we must. Senator Kennedy.
Thank you, Mr. Chairman. I want to thank Chairman Whitehouse for calling this subcommittee hearing, and I think he is my friend, as he knows, and I'm looking forward to working with him and every member of this committee on both sides of the table and the aisle on the issues before this committee. Before I begin my prepared remarks, I'll make an observation. It's been my experience that senators generally approach hearings in one of two ways, sometimes both, but generally one or two. To make a point or to learn. Sometimes both, but usually it's one or the other. And I'm certainly not criticizing either approach. I've used both. I came here today to learn. And I want to listen and intend to listen very carefully to our distinguished witnesses. I did want to make a few formal points for the record. I think that all of us, both Republicans and Democrats and independents, can agree that our people deserve the very best government we can give them. As a result of human frailty, sometimes they don't always get the government they deserve. We're here today to look at the connection of money in our federal judiciary. The debate over money in politics is not new, but I think the partisan, I'll call it bickering in Congress over the Supreme Court and other federal benches has almost reached a fever pitch. During the last administration, I personally witnessed an unprecedented level of vitriol leveled at Justice Brett Kavanaugh and Justice Amy Coney Barrett. Their confirmation proceedings at times became circuses without a tent. And if I never see any genitalia-shaped headgear in my life, I can die a happy man. I was disappointed in that. Other nominees for federal judgeships have also been targeted, and nominees have been targeted for their personal beliefs, including their belief with respect to human life and when it begins. And I hope that in this Congress we can do better, and I mean that sincerely. I don't mean that to be a political statement. I think a balance has to be struck. I have many friends on the Democratic side that decry the influence of money when it comes to influencing the government. I have many friends on the Republican side who decry the same thing. But I would observe it's important to keep in mind that in criticizing someone, it's important to take a look at both sides. And there have been days here in Washington when I have believed or observed that if it weren't for double standards, we wouldn't have any standards at all. And that's not a good thing, because the American people may not read Aristotle every day. They don't have time, but they get it, and they know hypocrisy when they see it. Our First Amendment has to be honored. And that's something that I hope we can talk about today. People have a right in America to express their opinion. You're not free if you can't say what you think. You're just not. Now, there are reasonable limits on that, as there should be. But we've entered, I don't know, I hesitate to call it a cancel culture, but I can't think of a better term right now. Where, yes, you still have a right to express yourself, but it could cost you your job. Or it could cost your spouse his job. And some people don't have thick skins. They're embarrassed when they're subject of tweets that trend on Twitter. And I think it's fair to say, for a variety of reasons, it's not limited to one political point of view or political persuasion. For a variety of reasons, we do live in a cancel culture. And I think we do need to be careful that you can technically say someone has a First Amendment right, but if they're canceled for exercising it, they really don't. On the issue of transparency, gosh, who can be against it? You know, but I think it has to be balanced with those First Amendment concerns. But I also want to make it clear, and this will be my final thought, I support transparency. I come from a state that, and there are other states like it. I'm not picking on Louisiana, but there have been times in my state's history, had it not been for transparency, some of our political leaders would have stolen everything that wasn't nailed down. And I'm not proud of that. That's not the case today, but there was a time. And I've always believed that the best way to resist temptation is a proper upbringing, a strong set of values, and witnesses. And that's all transparency is. So I don't want any of my remarks to be construed as not supporting that as an ideal. And once again, I thank you, Mr. Senator, Chairman, General White House, for calling this hearing today.
I thank Ranking Member Kennedy, my friend, for his remarks, and I turn now to our first witness, Lisa Graves, who is appearing electronically with us, assuming that our electronic team can bring her to life on these screens. Her full testimony, which is really quite thorough and impressive, will be made a part of the record, and she has 7 minutes for a summary of it. Thank you. Ms. Graves.
Thank you for the thank you, Chairman Whitehouse. Thank you for the invitation to testify, Chairman, Ranking Member Kennedy, and members of the subcommittee. My name is Lisa Graves, and I'm the president of the Center for Media and Democracy, a nationally recognized watchdog group. I also help lead a number of historical research projects like ALEC Exposed, Bold Rethink, and Koch Docs about oil billionaire Charles Koch. Our democracy is facing a trio of extraordinary challenges right now. There's a deadly pandemic that some refuse to take seriously, even as it ravages families, communities, and our economy. There's a lucrative monetization of poisonous lies about our election. And there's a calamity of dark money that is super amplifying the voices of the super rich and corroding the integrity of our court system. Thank you for inviting me to speak with you about that calamity in our courts. I first began earnestly studying America's judiciary more than 30 years ago, and I've devoted much of my career to trying to protect fair courts for all. I served as a senior advisor in all three branches of the federal government, where I focused largely on the judicial appointment process. I have a deep reverence for the vital role a truly independent and fair judiciary plays in a healthy republic to ensure both that the laws adopted by those we elect to represent us are fairly applied and that the sacred promises of our Constitution are faithfully kept. I've been keenly focused on the judiciary because for most of Americans' history, the Supreme Court failed to play that role, despite what we were taught in middle school. The court had terribly failed Black Americans, indigenous tribes, millions of workers of all races and ethnicities, generations of women, brave conscientious objectors, and those imprisoned though they had done nothing wrong, like Fred Korematsu. But after World War II, the Supreme Court finally had a complement of genuinely independent justices with the courage to insist that equal protection of the laws in our Constitution meant what it said for Black school children eager to learn in Topeka, that freedom of speech applied not just to the powerful, but also to white kids passionate for peace in Des Moines, and that the right to counsel meant exactly what it said for the impoverished Clarence Gideon and so much more. But the backlash against those landmark rulings that finally enforced the human rights of ordinary Americans was swift, and it has endured and expanded, adding grievances by elite CEOs who object to the rights of workers to form unions, and who consider laws limiting the ways industries can harm our only planet to infringe on their liberty. There's a through line from the regressive forces who sought to impeach Chief Justice Earl Warren to Richard Nixon's cynical invocation of law and order, all the way through to the free market fundamentalists peddling legal and policy arguments about limited government as a cloak for limited democracy. But the secret cash involved in trying to capture the court nowadays is massive. The impulse to use tradition as a weapon and the temptation to use storehouses of money as secret power supercharged by social media has been turned into a multi-million-dollar industry trying to capture our courts and turn back the clock. As a result, our nation's highest court is engulfed in dark money. Over the past decade, special interests have pumped hundreds of millions of dollars into sophisticated campaigns to influence judicial nominations, judicial decisions, and judges themselves through a dizzying array of dark money nonprofits and limited liability corporations. As CMD's Executive Director Arne Pearson has noted, that tsunami of cash is not a positive sign of civic engagement. It is an exercise in raw power. The Supreme Court will issue rulings about whether we can access affordable health care to lengthen our lives, if we can protect our right to vote from officials determined to suppress it through simple-minded or sophisticated tactics, if we can regulate carbon and secure a more livable planet, and even if we can limit corruption by disclosing the wealthy interests trying to buy results. As a Federal Society leader, Leonard Leo told right-wing donors at the Council on National Policy, quote, "Judicial confirmations these days are more like political campaigns," he said. To which I say, then let's treat them that way, by regulating them as such, as the chairman has proposed. I think the process for choosing judges and the techniques for influencing their rulings need even greater transparency, because judges are supposed to be fair, and they are appointed to jobs for life. Some will argue that there are far larger empires of dark money on the left. And while we disagree, that argument has no bearing on the merits of the reforms that are coming before this Senate. That the proposed disclosure rules would apply regardless of the point of view or the interest of those influencing the judiciary. Nevertheless, I must emphasize that there is simply no evidence that there was anyone on the left playing the kind of singular role Leonard Leo has played in the selection of Supreme Court and lower court judges, the marshaling of resources to secure their confirmation, and the role he and his major donors have played in unleashing the flotilla of amicus briefs the chairman spoke about last October. As Bob O'Hare and Sean Boberg of the Washington Post have documented, Leo has boasted to his donors that due to those appointments, America stands at the precipice of what he calls a revival of this, quote, structural constitution, hearkening back to before the New Deal, back to the robber baron era. The Washington Post estimated the combined revenue of the dark money groups in Leo's judicial influence network to be $250 million between the years 2014 and 2017. That was before the Brett Kavanaugh nomination. When 2018 tax filings are added into that tally, along with new Leo-connected entities, the total reaches more than $400 million. That doesn't include the spending after Barrett's nomination or by Koch-controlled groups or other groups. During this period, Leo's assets appeared to increase, allowing him to pay off his home mortgage years and years ahead of schedule and close on a mansion in Maine, literally on the day the Senate voted to invoke cloture on Kavanaugh's nomination. The Federal Society filings show he took a significant pay cut to spend time, quote, volunteering to help Trump choose judges, but he was not required by law to file any White House financial disclosure forms. What are the results? 5 of the current justices of the Supreme Court are former Federal Society members or frequent flyers, and 86% of the appellate judges appointed by Trump were members. Just as judicial appointments have become a de facto political campaign, getting a case heard by the Supreme Court and submitting coordinated amicus briefs has become a de facto form of lobbying. The number of amicus briefs before the court has soared in recent years, as the National Journal found, saying that justices cited those briefs in 65% of the cases last term. In preparation for this hearing, the Center for Media Democracy examined a sample of amicus briefs in 5 cases. By searching tax records, our researchers found that between 2015 and 2019, a total of $116 million was donated by just 12 funding vehicles to 18 repeat player groups that filed amicus briefs in 3 or more of those cases. 40 million of that came from 3 right-wing donor advised funds: Donors Trust, Donors Capital Fund, and Bradley Impact Fund. Another 47 million came from Koch-related entities. I'm telling you that it is well past time for there to be mandatory disclosure of the major donors of those effectively lobbying the Supreme Court. Finally, the lack of a binding code of conduct for the Supreme Court means our highest court has the lowest binding ethical standards, none. In my written statement, I detail a truly shocking array of very troubling problems relating to conflicts of interest, disclosure of outside family income, gifts, junkets, and more. Many of these anecdotes unfortunately involve Justice Clarence Thomas and his wife, Ginny. In American democracy at its best, we have a right to expect judges to be fair and not favor powerful corporations or special interests, as those moneyed interests play an increasing role in appointments, amicus briefs, and other means of influence. The integrity or trustworthiness of judicial decisions is essential to having a system of justice worthy of respect and deference. These are some of the reasons why the Center for Media Democracy strongly supports crucial reforms like those contained in the For the People Act, the Disclose Act, the Amicus Act, and the Judicial Travel Accountability Act. Thank you for considering our views.
Thank you, Ms. Graves. Let me now call on Professor Klarman, coming to us from Cambridge, perhaps.
Thank you, Chairman Whitehouse, Ranking Member Kennedy, and members of the subcommittee. This is my first congressional testimony. I'm honored and humbled by the opportunity. Democracy, as you know, is under threat around the world. Countries such as Poland, Hungary, Turkey, and Brazil have all experienced substantial democratic deteriorations over the last decade. Astonishingly, this democratic degradation has even adversely affected the United States, according to democracy ratings of Freedom House. American democracy is under assault from multiple directions. Our last president displayed an openly authoritarian bent. He attacked the press as the enemy of the people, assailed judicial independence, politicized the Justice Department and the intelligence agencies, encouraged political violence, undermined fundamental norms of government transparency, delegitimized elections, and manifested a bizarre admiration for foreign autocrats. In the months following the 2020 election, that president propagated the big lie that the election had been stolen from him, solicited election fraud from the Georgia Secretary of State by demanding that he find enough votes to change the outcome, and on January 6th, he incited a violent coup against the Capitol. Congressional Republicans were surprisingly complicit with that president's authoritarian bent. They did not want the 2016 Trump campaign's involvement with Russia investigated. They were untroubled by the president's systematic obstruction of that investigation. They voted against his impeachment and removal from office over his shakedown phone call to the president of Ukraine, and did not object to his systematic obstruction of congressional oversight. Of possibly greater significance has been the GOP's assault on democracy over the last 15 years through a wide variety of state electoral practices. Republican-controlled state governments have suppressed votes through restrictive voter identification laws and purges of the voter rolls. They have grotesquely gerrymandered legislative districts, enabling Republicans to maintain control over state legislatures in the House while failing to win majorities of the vote. They've also erected obstacles to college students voting, delayed elections that they anticipated they would lose, eviscerated the powers of Democratic governors, rejected the results of voter initiatives of which they disapproved, imposed obstacles to putting such initiatives on the ballot in the first place, and created crippling legal barriers to voter registration drives. In the month prior to the 2020 election, Republican elected officials across the nation made it harder to vote during a once-in-a-lifetime pandemic, refusing in some states to expand excuse-based absentee balloting, restricting the availability of drop boxes to collect such ballots, refusing to relax witness signature requirements for those ballots, and declining to allow the counting of absentee ballots postmarked but not received by Election Day. Since the election, we learn every day about new assaults on voting by Republican legislatures, especially in states that have recently turned against the party, such as Georgia and Arizona. These assaults include new restrictions on absentee balloting, more stringent voter identification requirements, reductions in early voting opportunities, often specifically those methods used disproportionately by African Americans, and promises of even more grotesque gerrymandering to come. Two factors explain this relatively recent Republican assault on democracy at the state level. This sort of behavior did not go on as recently as the 1990s. First, the national electorate today is more evenly divided than it was for much of the last century, which means that suppressing a few thousand votes can affect election outcomes with enormous political consequences. Second, dramatic demographic changes together with increased secularization and growing social liberalism have led Republicans to conclude that their political agenda no longer commands majority support. Recognizing that their party performs better when voter turnout decreases, Republicans have chosen to shrink the electorate rather than to make their policy agenda more popular. Republican Supreme Court justices have been largely complicit with this assault on democracy. In 2013, they effectively nullified the preclearance provision of the 1965 Voting Rights Act, one of the most consequential and noble statutes ever enacted by our federal government. Republican justices have also upheld strict voter identification laws and purges of the voter rolls on the basis of the state's interest in reducing voter fraud, which numerous studies have demonstrated is a virtually non-existent problem. In 2019, the Republican justices refused to remedy the problem of partisan gerrymandering, which today mostly benefits Republicans. The Republican justices have also unleashed a virtually unrestricted flow of money into politics on the basis of contrived constitutional rationales, which disproportionately benefits wealthy donors, corporations, and well-funded interest groups. 10 years ago, the Republican justices ruled that corporations have the same free speech rights as people, an extraordinary departure from precedent, original understanding, and common sense. In the run-up to the 2020 election, the Republican justices deferred to Republican elected officials who sought political advantage by seeking to make it more difficult for citizens to vote during a once-in-a-century pandemic. Rather than defending democracy, the court under Republican control has become another engine of democratic degradation. More generally, today's Republican justices have aggressively advanced the GOP's agenda. Comprising the most conservative court since before World War II, today's Republican justices have avidly championed the interests of the U.S. Chamber of Commerce. They've undermined public sector labor unions by interpreting the First Amendment in a departure from decades-old precedent as giving workers a right to be free riders, that is, benefiting from union protection without paying membership dues. Republican justices have protected corporations from punitive damage awards by inventing previously unheard of due process protections. They've drastically pared back class action litigation by essentially rewriting the federal rules of civil procedure to impose more stringent requirements on the certification of a class, thus fulfilling a longtime wish of the Chamber of Commerce. Republican justices have also stretched to sustain forced arbitration agreements that compel corporate employees and customers to air their grievances not in court, but rather in arbitration proceedings that are rigged in favor of the corporations. Lastly, today's Republican justices have advanced the social agenda of today's Republican Party, eroding the constitutional right to abortion, invalidating gun control measures on the basis of a novel and historically unsound interpretation of the Second Amendment, and threatening to invalidate race-based affirmative action on the basis of a colorblind reading of the Constitution that has no firm grounding in text, original understanding, or judicial precedent. Today's Supreme Court has shown itself to be no friend to democracy, but almost always a friend to the Republican Party. Thank you very much.
Well, I got to say, I'm impressed with, if nothing else, your timing. Professor Klarman, you hit it to within about 5 seconds of your 7 minutes, so well done. And that will call up Ben Jealous. Mr. Jealous, would you please share your remarks with us?
Thank you, Chairman Whitehouse and Ranking Member Kennedy, for the opportunity to testify today. My name is Benjamin Todd Jealous. I'm president of People for the American Way. We are more than 1 million citizens dedicated to the ideals of freedom, equality, opportunity, and justice for all. Throughout my career as a community organizer, investigative reporter, and civil rights leader, I've been inspired by Supreme Court rulings that moved our country closer to the promise of liberty and justice for all. That promise has been hurt by the pro-corporate activism of the Supreme Court under Chief Justice John Roberts. Today, I will touch briefly on 3 areas. First, voting and democracy. In Citizens United, a 5-4 majority ruled that it is unconstitutional for Congress to provide our elections, to protect our elections from unlimited spending by corporations. Citizens United and other rulings enhanced corporate power by unleashing a flood of big money and secret spending. Corporations' power was further enhanced by the court's decision to gut Section 5 of the Voting Rights Act. Section 5 provided key protections to Black and Latino voters, voters who we know are most likely to support worker protections and environmental regulations. As my friend Van Jones has often said, there is no green vote without the Black and brown vote. Roberts said it was okay to get rid of Section 5 because voter discrimination wasn't as bad as it used to be. Legally, it made no sense to ditch preclearance because it was working. The late Justice Ruth Bader Ginsburg said it was like throwing away your umbrella in a rainstorm because you're not getting wet. It had a powerful political impact. Within hours of that ruling, some states began to enforce voting restrictions and throw people off voting rolls. And that continues today. As we speak, 43 state legislatures are considering ways to make it harder for Americans to vote. The demographic groups hit hardest by those laws, Black and Latino voters, are less likely to support pro-corporate, anti-consumer, anti-environmental, anti-worker policies. That brings me to my second point. The Roberts Court's rulings against workers and unions undermine an important check on corporate power. In our country, there are two types of political power: organized money and organized people, and they are often at odds with each other. In the Janus case, Justice Neil Gorsuch provided the fifth vote to overturn long-standing workplace rules and weaken unions. That tipped the balance of power even more strongly towards corporations' almost unlimited organized money. My third point is about religious freedom. People for the American Way was founded to defend the First Amendment and its protections for religious freedom. They have allowed diverse communities of faith to flourish in this country. George Washington expressed the spirit of our founders in a letter to a Jewish congregation in Newport, Rhode Island. He assured them that they shared the same rights as other people in this country, adding that the US government would give bigotry no sanction and persecution no assistance. The Roberts Court has contorted these values. It has converted religious freedom from a shield to protect worshipers into a sword to attack workers. The 5-4 ruling in Hobby Lobby allowed corporations to deny legally required health benefits to workers based on a company owner's religious beliefs. Letting corporations use religious claims to evade laws designed to protect workers was, as Justice Ginsburg said, both unnecessary to protect religious freedom and like entering a minefield. The corporate war on the people's court is a threat to every person in this country and the values that unite us as a people. While I am a Democrat, it is important to note this is not a partisan issue. Whether you spend more time with liberals or libertarians, you will hear concerns over the power that big corporations have in our society, our government, and specifically our courts. That is why bipartisan majorities, people of this country, support the policies in the For the People Act, which would limit corporate power over our elections. As members of the Senate, you have the power to pass the For the People Act, and we hope you do. And we pray that as members of this committee, you will support the confirmation of fair-minded judges who have spent their lives serving the people rather than those who have spent their lives serving corporations. And consider other reforms to rescue our courts from corporate domination. Thank you very much.
Thank you very much, Mr. Jealous, and thank you for your terrific leadership of your organization and of the NAACP beforehand. I now turn to Mr. Walter. Yeah, Mr. Scott Walter.
Well, thank you so much, Chairman Whitehouse, Ranking Member Kennedy, distinguished members of the subcommittee. Thank you for the opportunity to speak, even though you may disagree with me. That's a great privilege in these grim days of silencing and canceling free speech, and I respect you for allowing it. I'm sure we all agree that democracy is disagreement. At Capitol Research Center, where I work, we study the sort of money flows discussed in the chairman's Captured Courts report. And I've paid you the respect of reading every word. Despite its 18 references to dark money, I was surprised the report doesn't define that term with any legal precision. Is it money in 501c3 nonprofits, in C4 nonprofits, C6s, and donor-advised funds? All those types of groups and more meet the report's vague criterion of, quote, funding for organizations and political activities that cannot be traced to actual donors. My preferred definition of dark money came from a witty man who said, dark money is support for speech the left wants to silence. That definition reveals how dark money conjures up a boogeyman. It shifts debate away from the substance of legal and political disputes to questions of money. And it implies that one's opponents are somehow nefarious just because they use the same funding arrangements everyone else does. Not that both sides are equal in dark money. By any measure, the left has far more dark money than conservatives, and the left's funding arrangements are sometimes more dark than conservatives. Before looking at the numbers, just consider, this very hearing is unthinkable without dark money flowing to everyone here, members and witnesses and both political parties. A decade ago, a liberal group coined dark money to refer only to C4 nonprofits, the independent expenditure groups that grew after the Citizens United decision. But now the term's used to encompass all nonprofits, donor-advised funds, sometimes super PACs. Those different groups have helped every member of this subcommittee get elected. Every single witness you've called today works at and collaborates with nonprofits that receive not completely disclosed support from donors on left and right. To paraphrase President Nixon, we're all dark money users now. Every single battle this committee engages in, every single political and judicial dispute the Captured Court report mentions, including judgeships, abortion, deregulation, forced union dues, every single one has groups that receive dark money and make arguments on both sides. Yet that simple fact, well known to everyone in this hearing, is never mentioned in Captured Courts, with one glancing exception when it says in passing that dark money is now used by Republican and Democratic interests alike. Even there, the report claims dark money was, quote, originally a Republican political device. The report gives no evidence for that amazing claim because it's false. The report says that in court battles, the right is, quote, fueled by hundreds of millions of special interest dollars whose sources are never fully disclosed. This money powers a complex network of think tanks, law school centers, policy front groups, political campaign arms, and public relations shops. Mr. Chairman, you make wonderful charts on all of those things, depicting the side you disagree with. I can make you charts of the identical things among your friends, and every chart I make will show more groups fighting more years with a lot more dark money. To be fair, you may not realize how vast and rich your side is because you've been misled by the partisan one-sided research you rely on from folks like the Washington Post and the Center for Media and Democracy. A few examples. To be fair, each time I'll cite a type of dark money your report criticizes, and then I'll cite the identical dark money used by your friends. First, foundations. Your report cites the Bradley Foundation because it funds groups and amicus briefs you disagree with. But why did your report keep in the dark the Ford Foundation, whose funding dwarfs Bradley's and whose influence on the court began decades earlier? Ford's influence has been enormous. Ford virtually invented the public interest law movement and helped get a reluctant Treasury Department to allow charitable status for those law firms, even though suing people hadn't previously been considered charitable. That tax law coup opened the floodgates for left-wing foundations to use dark money to fund lawsuits. Second, public interest law firms. Your report criticizes the Pacific Legal Foundation, but it was founded years after Ford's big expansion of such firms on the other side. Third, donor-advised funds. Your report criticizes Donors Trust, but it's no different from the Tides Foundation. Tides was the first ideological donor-advised fund provider, created a quarter century before Donors Trust, and for the years your report uses to compile dark money, Tides disgorged almost twice as much. Fourth, C4 groups that campaign for and against judicial nominees. You target the Judicial Crisis Network, but today you invited People for the American Way. That's also a C4, and it invented public multi-million-dollar nomination campaigns in 1987 when it smeared my friend Bob Bork with Gregory Peck ads. Incidentally, the People for the American Way was originally launched out of the Tides Foundation's dark money empire, which has long funded it. Tides dark money also goes to the Center for Media and Democracy. Fifth, your report criticizes a conservative network of groups working together. You said that network over 5 years raised $250 million. But your report ignores the network of front groups run by the little-known Arabella Advisors, even though Arabella Advisors runs Demand Justice and Fix the Court, the groups that are the tip of the spear for your friend's network. Again, your report criticizes the conservative network that raised $250 million over 5 years, but Arabella Advisors Network, over the same 5 years, raised $1.5 billion. Now let's look at the big numbers. If dark money means C4 nonprofits, you and your friends have been ahead for half a decade. In the 2018 cycle, Issue 1 reports the left got 54% of the cycle's $150 million. In the 2020 cycle, the Democratic Party's presidential candidate won the dark money race by roughly $132 million to $22 million, according to the Center for Responsive Politics. If dark money means C3 nonprofits like the Bradley Foundation, you're even more ahead. Our last study found leftover right funding of public policy C3 groups is 3.7 to 1. In raw dollars, we're talking $2.2 billion for conservative groups, $8.1 billion for liberal groups. So you and your friends have more groups who fought these battles much longer and with much more dark money. Permit me a note on fundraising. Every member of this committee is a fundraiser. Is it nefarious when you raise funds from people who agree with your arguments? Of course not. Is it corrupt when you hire staff who've worked in other offices or in outside groups? Of course not. Every member here is proud to fight for what he or she believes in, to raise money for what he or she believes in, to work with anyone who will join you in your fight. Mr. Chairman, the people that your report targets are no different from you and your friends. They just have less money.
Thank you, Mr. Walter. We now turn to Professor Adler. Professor, the floor is yours.
Thank you. It's a pleasure to be here, Mr. Chairman, Ranking Member Kennedy, and members of this subcommittee. I thank you for the invitation to testify today about the Supreme Court. I care deeply about the court. It's been the focus of much of my scholarship and research, with a particular focus on the Roberts Court and its relationship to business. I also care deeply about the values of accountability and the rule of law, which is one of the reasons why I helped co-found Checks and Balances 3 years ago. So these are issues that matter quite a bit. An important aspect of the rule of law is certainly our judicial system. And it's distressingly common for those who disagree with the Supreme Court's decisions to question the motivations of the justices, rather than address the substance of their decisions on the merits, or where applicable, seek reform of the relevant laws at issue in contested court decisions. The court's critics too often prefer to demonize the justices and imply nefarious motivations. And I'm afraid we've seen some of that today. Much public commentary on the Supreme Court fails to engage with the court's actual jurisprudence and instead seeks to apply reductionist labels to the court's work, focusing more on outcomes rather than the rationales and legal authorities. Commentators label the Roberts Court activist and accuse it of being an instrument of corporate interests or dark money. Such claims are misleading and overwrought at best. Some such claims are simply false. For example, by standard measures, the Roberts Court has been less activist than was the Warren Court, the Burger Court, or the Rehnquist Court. Specifically, the Roberts Court both overturns prior Supreme Court precedents and holds federal laws to be unconstitutional at a significantly lower rate than did its predecessors. And it's not particularly close. Moreover, such decisions have not moved uniformly in one ideological direction. For every Janus or Citizens United, there is an Obergefell or a Windsor or a Boumediene or a Ramos. The Roberts Court is actually more of a status quo court than an activist court, and it has been more status quo oriented and more deferential to Congress than any court in the past 60 years. We can disagree or agree with the court's decisions, but that is simply a fact about how this court has acted. The decisions of the Supreme Court under Chief Justice Roberts are best explained, understood, and predicted as a consequence of the respective justices' jurisprudential and doctrinal commitments, and not as a consequence of undue favoritism for or undue influence by any particular interest group, economic or otherwise. This is why business groups win some cases and lose others. This is also why the conservative justices that form the court's majority agree with each other in some cases and disagree in others. If the Supreme Court or a majority of the current justices were enthralled to a corporate agenda, one would expect that business groups would most often prevail where the stakes are the highest, where business interests had the most to gain or the most to lose. Yet with few exceptions, that is not at all what we have witnessed from the Roberts Court. While business groups routinely prevail in cases asking the Supreme Court to corral a wayward appeals court decision or reject an innovative, if also unprecedented litigation theory, they regularly lose when the law is against them, when they seek dramatic changes in doctrine, particularly constitutional doctrine. And this has occurred often in some of the most consequential cases before the court. If the Roberts Court were truly enthralled to a pro-corporate agenda, it would be hard to explain decisions like Massachusetts versus EPA, or EPA versus EME Homer City Generation, or Wyeth versus Levine, and I could go on and on. One just looks, for example, at the court's federal preemption jurisprudence, an area that business interests care quite a bit about. One cannot see any evidence of corporate influence. One cannot explain decisions like Chamber of Commerce versus Whiting or the recent Virginia uranium decision based on any theory about corporate influence. We can explain those decisions if we pay attention to the individual jurisprudential preferences of the justices. Roberts Court is certainly a conservative court on most issues most of the time, and sometimes conservative rulings do help business, as when the court refuses to recognize new implied causes of action or bless the latest theory for a new type of class action. But sometimes conservative rulings do not advance business interests, and all of the justices, on both the left and the right, place their jurisprudential commitments ahead of any desire to help or harm a particular interest or a particular group. None of this is to say that political and economic interest groups do not seek to influence the court. Of course they do. The court's decisions are important, and people care greatly about how the court's decisions come out. This hearing is a testament to that. Organizations on both the left and the right invest substantial sums to support their causes and influence the judiciary, whether by influencing the confirmation process or encouraging the court to reach particular conclusions. Some groups even see such conflicts as a fundraising opportunity. But there is nothing nefarious about groups of Americans seeking to have their voices heard about the actions of their government. If a single free video game, Fortnite, can net over $1 billion in a single year, I'm not sure why $250 million over 5 years is signs of a crisis. What we should admit is that efforts by ideological and economic interests to influence the federal courts are an inevitable consequence of turning over so many political and economic questions to the federal courts. The more that is at stake in the federal judiciary, the more various interests and factions will seek to ensure that their perspectives prevail. The only way this will change is to make the courts less central to the political and economic life of the nation. As the range of issues touched and constitutionalized by the courts has expanded over the past century, so too has the value of influencing judicial decisions. This in turn has increased the incentive to influence the court's behavior, whether through the nomination process, amicus briefs, or even overt efforts to place political pressure on the courts. If judicial decisions instead of votes in Congress are going to resolve the key questions of the day, then that is where political and economic interests will focus their resources and attention. If we want to lower that incentive, we have to lower the stakes. The more questions Congress can resolve itself, the less pressure there will be on the courts to resolve those same questions. The less Congress leaves to the courts, the less people will care about who is nominating or confirming individual judges. Congress could facilitate this process by taking more care in drafting statutes, regularly reauthorizing federal programs, and restoring the traditional legislative process, as well as by avoiding partisan attacks on judicial integrity and independence. Moreover, if the confirmation process were turned to a focus on judicial qualifications, interest groups would not feel the need to invest so heavily in confirmation battles. These and other steps are things that Congress could do to help. Thank you again for the opportunity to present my views, Mr. Chairman. I hope that my perspective has been helpful, and I am happy to answer any questions that you or other members of this committee may have.
Thank you, Professor. I appreciate it. For the questioning, I'm going to begin with Chairman of the committee, Senator Durbin, who has joined us here in the subcommittee hearing, and we'll yield him my time. I'm going to be here till the bitter end, so I will go last.
Thanks very much, Chairman Whitehouse, and thanks for having this hearing. I know of your intense interest in the subject and your ample research on the matter far beyond any other senator that I know. You've tackled this issue, and today bring in some experts for us to test their opinions. I have a statement for the record I'm not going to read, but I would like to say a few things. Just this week, we were reminded of how dark money operates. A right-wing dark money group called the Judicial Crisis Network, well known to most senators, has targeted Vanita Gupta, President Biden's nominee to be Associate Attorney General, with an ad campaign with vicious and blatant lies. In a recent editorial, the Washington Post called the ad that they are running a, quote, baseless smear campaign, categorically dishonest, and mainly notable for the magnitude of the lies and distortions it crams into 30 seconds. This wasn't our first experience with the Judicial Crisis Network. They are certainly known for spending millions of dollars in dark money to block the nomination of Judge Merrick Garland to the Supreme Court 5 years ago. What an irony that today Judge Garland gets his next assignment in public life with a bipartisan vote, I might add, in the United States Senate. Maybe that's a portent of good things to come. I certainly hope so. I'd like to know more about the Judicial Crisis Network. I'm not saying they don't have a right to speak their mind, but I think we have a right to ask, well, who paid for it? Who's really behind this effort? You know, when you bring up this question with some, they say, well, if you disclose the sources of money for these dark money efforts, it will scare them away. They don't want to be terrorized by the press or anyone. They want to be able to just exercise their corporate free speech or free speech, whichever it is, and to do it without fear of retribution. Interesting. To argue that point of view with a group of senators who are obliged under law to disclose all of their donors virtually, certainly any significant donors. We live with that. That's our standard of operation. There may be many areas that could be questioned about how we raise money for campaigns, but certainly disclosure is not one of them as far as I'm concerned. I think it is perfectly appropriate to disclose the people who contribute to my campaign. Now, having said that, we all know what's going on with super PACs and other entities, and I'll save that for another day. But I will just say the bottom line as far as I'm concerned is this. I don't think any of us have any doubts of how the American people would answer the following question. Do you believe we need longer political campaigns? I think I know the answer to that. Do you believe that we need more people putting negative ads on television in their campaigns? We know the answer to that too. And we are now reaching a breaking point, I'm afraid, in this whole process that is going to discourage the common woman or man from even engaging. So I salute you for bringing this issue before us. I'd like to make one last point. In the notes I have read in preparation for this, I understand that now this dark money effort is going toward the voter suppression campaign across America. In 40 states, 250 proposals, all of which are designed to restrict voting in America. Now, I'm an amateur student of history. I quickly underline amateur. And I see recurring themes. Ku Klux Klan appears and reappears about every 50 years. If you look at history, 1865, 1915, mid-50s to 60s, and now again in some new form. The effort of voter suppression appears and reappears in history. When it first started in 1890, during the Jim Crow era, there was something called the Mississippi Plan. The Mississippi Plan was an ingenious device by racists to preclude blacks from voting. Count the butter beans in a jar, answer questions on the Constitution, pay a poll tax, literacy test. All of these were designed to stop African Americans from voting. They were successful. They drove down voter participation in some of the states in the South in the 20th century, beginning of the 20th century, to levels we've never seen before, thank goodness, and won't see again, I hope. But it worked. And now there is an effort underway to impose voter suppression across the United States again to suppress the votes of black and brown people. Why is this a recurring theme in American history? And what does it say about us that we want to make it more difficult for people to exercise their right to vote? If there is fraud, go after it, whoever's benefiting from it. But certainly this president has proven claims of fraud don't meet the laugh test or even the evidence test when he takes them to court. I'll close by saying this. Monday of this week, the last Trump case to go to court went to the Supreme Court and was dismissed without comment. It's an indication of even a president with millions of dollars cannot manufacture fraud where it doesn't exist. So I would say the voter suppression efforts across this country are a sad commentary that we have not learned a lesson of history. I think we all understand that if you're going to win an election, you have to have a winning message. Simply deciding that you'll reduce the number of people voting is not a winning message. I yield.
Senator Kennedy.
Thank you, Mr. Chairman. Mr. Jealous. Come on until I stop until I'm finished.
When he speaks, he'll come up.
Mr. Jealous, let me apologize in advance. I may have to interrupt some of your answers because we only have 5 minutes. I'm not trying to be rude. I just got a number of questions. I appreciate your passion. I confess I don't understand exactly what you're alleging. I get the part where you think that corporate money and dark money is dangerous. And I got the part where you don't think Chief Justice Roberts is doing a particularly swell job, nor do you like many of his opinions. Connect those two for me. I mean, are you suggesting that someone is using the corporate money to bribe the Chief Justice?
For me, I was having trouble hearing at the very beginning.
You mean I got to repeat all that?
No. I heard the question, sir. At the very beginning, I couldn't hear who you were addressing it to. I wanted to make sure that it was to me before I answered. That's all, sir. So sure. I'm not a lawyer, but as a former investigative...
But are you, just help me get to the bottom line. Are you suggesting that someone's using the corporate money or the dark money to bribe the Chief Justice?
What I'm suggesting, sir, is that there's a rigged system that's pretty obvious. I mean, when you look at the Chamber of Commerce...
What do you mean by rigged?
What I mean by rigged, sir, is that you've got dark money spending $18 million to put a pro-corporate justice on the Supreme Court.
How do you know that's influencing the way the Chief Justice decides cases?
Well, sir, it's notable that the last two, that the justice who got held back didn't have $18 million.
But how do you know that money is influencing the way the Chief Justice decides cases? Now, you've made a very serious allegation. Tell me how you back it up.
Sir, what I described is a rigged system in which you have dark money campaigns.
Wait, Mr. Jones, I'm sorry, but
justices onto our Supreme Court.
I'm trying to stay on the subject. I listened patiently to your speech, and I appreciate your passion. But we need to connect the two. You've made some pretty serious allegations.
And
now,
sir,
are you saying that this dark money and this corporate money is being used? Let me put it another way. Are you saying the Chief Justice is voting the way he's voting because of this dark money and corporate money?
In part, sir.
Okay. Let me ask. I'm sorry to cut you off. Let me go to Ms. Graves. Ms. Graves, I appreciate your passion too, and I got the part about the Federalist Society. And I got you, and you made some comments about dark money going to the Federalist Society. And you talked to, I take it you're not a fan of Justice Kavanaugh's nomination. How do you connect those two? Are you suggesting that the Federalist Society bribed somebody to nominate Justice Kavanaugh?
Senator Kennedy, the record shows that Donald Trump outsourced the pre-selection process for judicial nominees to Leonard Leo, who has long been the vice president.
I understand. I remember that. But I'm trying to understand what you're alleging. Are you alleging that the Federalist Society bribed the President of the United States to nominate Kavanaugh with this dark money?
What I'm saying, Senator, is that the record shows that this Federal Society and Leonard Leo has exercised extraordinary influence over handpicking who gets on the court. And then he went to donors at the Council on National Policy to tell them that due to these selections, America was at the precipice of a revival of laws dating back more than 100 years.
Yes, ma'am, and I listened to your speech, but I'm trying to understand. You got to connect up. These are serious allegations you're making, and you've got to connect up the money to the decision.
Yes, certainly, sir. And in fact, Leonard Leo made.
But are you saying that Trump would not have selected Kavanaugh but for this dark money?
What I'm saying is that it's quite clear that these individuals were handpicked by Leonard Leo for Donald Trump to choose from because he thought that they would advance his agenda. And his agenda.
How do you know that?
Because he told the Council on National Policy in his own words.
No, he said he said he was influenced by. I'm not defending him, but he said he was influenced by the. How do you know what was in the president's head?
I don't think anyone knows what's in that president's head, Donald Trump's head. But I think that what's clear is that he spoke many times about how he was giving the role of choosing to the Federal Society. The Federal Society has advanced a number of positions.
Okay,
through.
Let me ask you one last question because I don't want to overdoing time. Are you suggesting that the Federalist Society is using this dark money to bribe anybody?
Senator, there's an array of ways in which the judicial function can be corrupted, and dark money is a way of corruption.
Well, are they bribing somebody? And if so, who is it?
Like a brown paper bag of cash is not the only way in which money can influence and distort the rulings of judges or of others. And so this issue of how you define bribery, I think, is somewhat of a red herring. In fact, before the people...
Do you think they're being bribed one way? Just tell me. If you do, it's okay. I just want to know what you're saying. Do you think that they're bribing anybody to have somebody nominated?
Senator, there's a legal definition of bribery in the United States Code that's a very specific, narrow definition.
Okay, I'm
that's
done.
not the layperson's definition of corruption and undue influence.
Mr. Lee, Senator Lee.
Thank you, Mr. Chairman, and thanks to all of you for being willing to testify today. Ms. Graves, I want to pick up with you sort of where you left off with Senator Kennedy. Now, you talk in your testimony a fair amount about the dangers of dark money to further conservative causes, but then you seem to leave out the liberal dark money organizations like the Tides Foundation, the Schwab Charitable Fund, the George Soros Foundation to promote open society, and of course, Arabella Advisors. I thought this might have been an oversight. That is perhaps until I realized that your organization, the Center for Media and Democracy, itself receives donations from these same dark money groups. And so in an effort to be consistent with your testimony today about the evils of dark money, will you commit that the Center for Media and Democracy will no longer accept these dark money donations?
Well, Senator, I think that there's a specific definition of dark money that is embodied in the statutes that seek to obtain disclosure of it. That's
okay, and how does that definition encompass the conservative organizations that you don't like and exclude the dark money that you receive? Tell me what the difference there is.
Senator Lee, what my testimony says is that I support these neutral laws applying to all groups equally, whether they're Democratic or Republican or progressive or conservative or libertarian, and that the standards are about their conduct in terms of influencing elections, spending money on advertising. There's a set of thresholds that's embodied in those measures that I think sets a very neutral and appropriate range for when money should be disclosed. And it doesn't reach a number of nonprofits that aren't involved in running ads around elections. It doesn't reach nonprofit activity around, hospitals or other charitable functions. It's specifically tailored to those entities that are running ads as if they were a PAC, like a political action campaign.
Will you agree to not take anonymous donations?
Senator, I received an anonymous donation several years ago, and it was anonymous to me. It wasn't just anonymous to the world. I don't know who the person
Okay, what
was.
about donations from groups that don't themselves publicly disclose their donor lists or the amounts that they've received? And also, how much of the dark money you received was used to support the filing of amicus briefs in the Supreme Court?
I reject your premise, Senator, quite respectfully, but there was no dark money that I received. Or that the Center for Media and Democracy received. And so I'm sort of puzzled by your premise. If you look at the definitions that are in the statute for the activity that Congress is attempting to regulate, it doesn't apply at all to the work that I've been doing in investigative journalism and the work that the Center for Media and Democracy has done.
Okay, I have to say, I'm very perplexed by the distinctions that are being drawn. As far as I can tell, we've got distinctions being made by our witnesses between conservative groups and liberal groups. Look, pick a horse and ride it. If you don't like dark money, that's one thing. If you like it, own it where you take it. But this middle ground of trying to suggest that it's holy, that it's righteous, if it's in support of a liberal cause, it doesn't sit well with most people. Let's go to Professor Adler for a moment. Professor, you mentioned in your testimony Chairman Whitehouse's report with the American Constitutional Society made much about the so-called Roberts Five between 2005 and 2006, and also the 2017 to 2018 term, and the number of so-called partisan decisions. But a closer look at those numbers shows that of the 212 5-4 decisions over this time period, that is from OT 05 through the end of OT 17, of the 212 5-4 decisions during that time period, over 60% were instances where a member of the Roberts Five sided with the liberal bloc on the court to produce a majority, while only 36% were 5-4 decisions, where the conservatives on the court stuck together. Would you expect the numbers to be different than that if the conservative groups and the justices that had previously been supported or defended by conservative groups were themselves beholden to nefarious special interest groups?
Sure, Senator. There are actually several reasons why I think those numbers are surprising, but in very different ways than in the report. First, as I note in my written testimony, the Supreme Court is only taking about 70 or so cases a year out of the thousands upon thousands that are in the federal courts, out of the hundreds of cert petitions that are filed. They're only taking cases, for the most part, in which lower courts have split. So these are cases in which lower court judges, very smart people with very capable clerks, giving their best effort, could nonetheless not reach unanimity about what the proper legal result are. So the Supreme Court's only taking the hardest cases in the federal court system to begin with. And then of those, only a small fraction of those cases are decided 5-4. And then of the 5-4 cases, even though you have 5 Republican appointed conservative justices, and 4 Democrat appointed liberal justices, you still only see 36% of the 5-4 decisions splitting along those lines. Given that these are the hardest cases, the cases that divide the lower courts so much, if what we were seeing was a conservative cabal that would vote as a bloc, we would not only expect the number of 5-4 decisions to be higher, we would also expect the number of 5-4 decisions decided along purely ideological or partisan lines to be larger than it is. And it is scarcely more than a third of the 5-4 decisions over that time period. I think that shows that what's driving the justices is not fealty to a team, of believing that they owe whoever may or may not have supported them years ago when they were nominated, but their best efforts to get the answer right. And in those really hard cases where the constitutional text might not be clear or the statutes might not be clear, the fact that we get disagreements among justices and that sometimes they line up based on their underlying judicial philosophy shouldn't surprise us. What should surprise us and I think actually inspire us is how often, despite these deep jurisprudential differences, they are able to be unanimous. They are able to decide cases 8-1, 7-2. That should give us confidence in our judicial system. And we should note the low number of 5-4 cases decided along ideological lines, because it really is a low number when placed into perspective.
I owe an apology to Senator Hirono, who is joining us electronically and who I skipped over. Let me turn to Senator Hirono now.
Thank you. Does that mean that I get 10 minutes? I would like to
I'll give you
associate
some consideration.
myself, I would like to associate myself with your opening remarks and the remarks of the Judiciary Committee Chair Durbin. I heard Professor Adler say that the Roberts Court is quantitatively business oriented, but not necessarily qualitatively so. I would say that one of the most consequential decisions that the Roberts Court made, which opened the floodgates to dark money, is Citizens United. I'd say that decision, you know what, we can argue about maybe some of the other decisions that weren't so consequential. Hey, to me, that is like an A1 consequential decision. So there you go. I have a question for Professor Klarman, Mr. Jealous, and also Ms. Graves. And I know that the chair is going to get to this, but the bottom line for me in this hearing is that we can argue all we want about who's accepting dark money, both the left and the right, conservative, liberal, accepting dark money. But the bottom line is that all of this should be disclosed. So I want to start by saying there is clearly dark money being used to fund political campaigns and activities. And there are arguments from Democrats that Leonard Leo, the Federalist Society, and the Brain Trusts have been using dark money to capture our federal courts. How do I know this? Because I've been sitting on the Judiciary Committee pretty much ever since I became elected to the Senate. So Republicans have been arguing that the left is increasingly using dark money. A simple solution would be to require everyone to disclose where their money comes from. But so far, only Democrats are supporting that. Only Democrats are saying that everybody's dark money should be disclosed. So for Ms. Graves, Professor Klarman, and Mr. Jealous, what role can disclosure play in addressing the dark money problem?
Senator, thank you so much for that question. And I think that that's precisely the point my friends and I have been talking about. While some of the witnesses on this panel want to talk about left spending, what's interesting is that if left spending is the biggest, why are almost all the left groups urging that the Disclose Act be passed? I think to draw this in a partisan line is unfortunate, because in fact it should be common sense, American values to say we want more transparency. We want to make sure that this dark money is not hidden. And I support what you said and how you described it, Senator.
Professor Klarman?
Well, I certainly agree with that. I think the case that was made by the other witnesses was a good argument for requiring the left to disclose dark money as well as the right. If you just asked an ordinary citizen their opinion, somebody's giving you advice, your doctor is giving you advice about what medication to take. Do you not think everybody would agree that they would want to know whether the doctor had a financial interest with a pharmaceutical company in prescribing a certain drug? Well, of course, the answer is yes. Everybody would like to know if the Coke network is spending money opposing light rail transportation that's up for a referendum in Nashville, and their argument is simply, oh, this is going to raise your taxes. Do you not think the ordinary citizen would want to know that the Koch brothers depend entirely on people continuing to use fossil fuel and drive their cars, thus they have they regard a light rail as an existential threat to their business? And the answer is, of course, everybody would want to know that. The only question here is whether there's some constitutional constraint. And I imagine we're going to talk more about. Well, there's NAACP versus Alabama, which is a very, very different case. So in 1958.
It is a very specific case. I'm somewhat familiar with the facts of that 1958 case. And to use that to protect the disclosure of dark money because some people might get hurt or whatever, I'd like to see the evidence. It's like there's no evidence that there was fraud in the elections, but that doesn't stop certain people from continuing to push out those kinds of positions. So yes, if that's the only case, that ain't much. Mr. Jealous, would you like to add to this discussion?
Yeah, I would just like to thank you, Senator. And it's deeply troubling and offensive that that case keeps getting used by the right. I've sat with the adult children of the martyrs of our association, of the NAACP. And the reason that the membership lists were protected at the time was that the Alabama state government was in league with the Ku Klux Klan in unleashing terror on our members, and we protected it to make sure that they would not be killed. I would ask, your colleague, Senator Lee and Ranking Member Kennedy, if they'd be willing to ask the groups that support them and their causes to disclose. What we're asking for here is simply bilateral disarmament for their, to turn on the light. And I know that Mr. Walter thought it was unthinkable to have a hearing without dark money. I guess there was a time in the US Congress when it was unthinkable to have a hearing without gaslighting, but we moved forward to the light bulb and we found that more light actually made the process work better. And so respectfully, I do think it's quite thinkable to have a hearing without dark money. And it's in fact what most of the people in the country want.
Exactly. I could go on. I just want to end by referring to some of the questions for Ms. Graves. The Federal Society or the Judicial Crisis Network is not spending $17 million to get people onto the Supreme Court because they're just, they've done their research as to where their the nominees that they're supporting are coming from. They are, of course, spending this money to support judicial nominees for lifetime positions that are probably more in alignment with their positions based on their prior records, their statements, their writings. Thank you, Mr. Chairman.
Thank you, Senator Hirono. You might want to stick around for 1 second. Senator Kennedy has exerted a point of personal privilege.
Yeah, Mr. Jealous. Thank you, Mr. Chairman. Mr. Jealous.
Briefly.
And I will be brief. Transparency is one thing. But that's not what you talked about in your opening statement. Now, what I heard you say, Mr. Jealous, was that Chief Justice Roberts would not have voted the way he did in many of the cases you criticized, but for this dark money and corporate money. Now, that's what you alleged.
Sir, what I talked about.
It's serious as 4 heart attacks and a stroke.
Well, sir,
that has
please,
nothing to do with transparency.
Sir, I don't want to have a heart attack, and I don't want you to have one, so just let me finish, please. And what I'd say, sir, is this, that the rigged system is pretty obvious when you see $17 million spent to push a nominee through, a pro-corporate nominee through. And the rigged system is even more obvious when you look at the hundreds of millions of dollars that are spent to push nominees through. And then it becomes even more clear, sir, when you dig in and you see how many of the same donors are supporting the Federalist Society, are supporting the campaigns of senators who will then preside over the nominations process. And the people of this country, sir, all we want is transparency, and that's bipartisan.
Yeah, but that's not what you allege, Mr. Jealous. You allege biggest doubts. You said you said that Chief Justice Roberts would not have voted as he did in some of the cases, but for this corporate dark money. Now that's a serious allegation.
I would refer you back to my testimony. It's all written for the specifics. What I described was a rigged system in which Chief Justice Roberts operates, in which the Supreme Court has become captured by corporate interests, in which the U.S. Chamber of Commerce, which respectfully does not represent Main Street or any small only corporations, when 70% of the cases that it submits.
Let me interrupt here just 1 second.
I'm sorry, Mr. Chairman. I abused my privilege and I ask your forgiveness.
Thank you, sir. And I think it's Senator Tillos's turn.
Thank you, Mr. Chairman.
You're welcome.
I want to thank the witnesses for coming here. And, it was interesting in your opening statement how you tried to be balanced somewhat in recognizing that the that there's dark money on both sides. You did make one comment I'm not quite sure I agree with, and that's at least in my brief time in politics for 14 years, I didn't see any catching up necessary on the Democrats' part. I don't know when that happened, maybe long before I got into public service. But I thought I'd talk a little bit about really giving some context. We have had hearings, and you've had floor speeches and comments in the committee talking about some conservative groups. But this is a CNN report, $320 million of dark money supporting White House and congressional campaigns just in 2020. And I know that very well. In my race last year, there was almost $296 million spent. The majority of the dark money came from liberal interests who either supported my opponent or tried to beat me into the ground. And the same was true in 2014, only the disparity was about by 2 to 1. I know that we have a number of members and a number of the witnesses, after your tone-setting opening statement, then launched into their liberal, from their liberal worldview of how the real bad dark money was on the conservative side. But I think we also need to understand the infrastructure, the anatomy of at least one example of dark money on the liberal side. I think one of the witnesses testified over about a 5-year period that Arabella Advisors has raised about $1.5 billion. Can you see that? Yeah. $1.5 billion, probably about 5 times more than the conservative. And the way that they do this is they provide money through Arabella Advisors, and then that money is funneled to any number of organizations. I think one represented here today, People for the American Way, Demand Justice, Take Back the Court. And they're intended to influence the courts. They clearly want to bring the court to their worldview. I do take exception to anybody that thinks that money influences the outcome of lifetime appointed judges. I think that they've proven to be independent. I think one of the witnesses said that it's hard to say that the Roberts Court has really been a conservative activist court. But these organizations are funneling through all these different groups, and they're trying to expand the court. They're trying to nuke the filibuster. They're trying to do all the things that liberal interest groups want to do. But just yesterday, we had Vanita Gupta in the hearing for her possible nomination as the Associate Attorney General. She's currently on leave. Let's move. Well, she's actually on leave. Let's go ahead and move to the final graphic. From one of these organizations that are in this ecosystem. She's right here under the umbrella of Arabella Advisors with, well, you can see the structure, 16th Third Fund and New Venture Fund. These groups gave money to Vanita Gupta's organization that went on to push the liberal agenda from the leadership conference. They used the money to influence the Supreme Court through direct candidate opposition, through AstroTurf campaigns, and supporting packing the courts and supporting the filing of amicus briefs. So I think I'm glad at least you acknowledged that the Democrats are in this game. And we're talking about dark money. I absolutely believe that some level of accountability or transparency may be appropriate if we're willing to talk about all of the sources of money. In the weekend after the untimely death of Justice Ginsburg, my opponent, through his campaign account, raised $6 million over 48 hours. And that comes through a new tool that we have, which I'll call dim money. That's aggregation tools that get $50, $200, $250 below any sort of reporting limit that are doing the same thing. I don't hear anybody on the Democrat side saying they want to get rid of those tools. So they're not suggesting a disarmament of both sides. They've simply found another way to do exactly the same thing. People providing money to candidates and influencing elections. They've just come up with a more sophisticated, broad-based policy that I doubt very seriously that they'd be willing to abandon, because among liberals, they're doing it to the tune of probably 10 to 20-fold what conservative candidates do. I think that we're in a time where we do have to recognize that some people's speech would be muted if you just simply disclosed everything. I've had the protesters out in front of my house before sunrise on 2 different occasions, dozens of them, blocking my driveway. I wonder if they were funded by some dark money group or by one of these aggregation engines that are not necessarily from millionaires. I think that in the time that we are today, as frustrating as it may be, and as frustrating as the cease and desist orders are to bring an ad down and see that same group bring another ad up in 72 hours, I don't think that it's time to actually strip away and unilaterally disarm, because I don't believe that the witnesses are being honest with themselves if they really do believe that that would actually net to zero. The Democrats have done an extraordinary job of raising money and funneling to campaigns, and they've come up with one that skirts under the dark money umbrella, but to me, it's an analog to exactly what we're talking about today. And I thank the witnesses, and I'm over time.
If it helps at all, Senator, tell us the Disclose Act, which has been my anti-dark money bill and applies to dark money on both sides, has been a matter of record for 4 Congresses now.
Would it apply to aggregators?
We have not had any such proposal. So we've never had a single Republican show any interest. Every vote has been against it. There's been no effort to try to work in a bipartisan fashion for a bill. So I hope that we can provoke something like this, because I will tell you what is a lot more rotten than the partisanship between us is the influence that nobody sees, because nobody knows who is behind the money. And I don't care which side that comes down, it is wrong. And I want to work with anybody who's willing to do that to try to get rid of that stuff. It is a poison in our democracy. Senator Cruz.
Thank you, Mr. Chairman. And I would note to the chairman that I have invited the chairman and other Democrats multiple times to join me in the Super PAC Elimination Act, which I've introduced in multiple Congresses, that does 2 very simple things. Number one, it allows unlimited individual contributions directly to campaigns. And number 2, it requires immediate 24-hour disclosure. And as a functional matter, it would eliminate super PACs and largely eliminate dark money, and it would do it on both sides. And that solution, we have yet to have a Democrat interested in actually doing this. I would note to my good friend Senator Tillis that the charts were really great with all the boxes. They would have been more persuasive had you used red yarn to connect them. I'm just telling it weaves a much better web and a much better story. You know, there are a lot of issues in politics on which we see hypocrisy. There's the old line that hypocrisy is the tribute vice pays to virtue. But maybe no issue has greater hypocrisy than debates over campaign finance reform and so-called dark money. Because Democrats thunder against dark money, and yet Democrats dominate dark money. If you look in 2016, of the top 20 organizations that gave money for political speech, 14 of them gave virtually all of their money to Democrats. If you look at the top 10 organizations and individuals contributing to super PACs, 8 of them, only 2 were Republican donors, 8 were Democratic donors. In that cycle, the top 20 super PAC donors gave $422 million to Democrats and $189 million to Republicans. Those numbers only grew. In 2018, Democratic dark money outnumbered Republican money 2-1, and in 2020, to defeat their nemesis, Donald J. Trump, Democratic dark money outnumbered Republican dark money 6-1. So all of the people thundering about dark money are getting elected with it. Now, Mr. Walter, we have at this hearing, albeit virtually, the leaders of groups such as the Center for Media Democracy and People for the American Way criticizing dark money from conservative groups. I want to make sure everyone understands. Does the Center for Media and Democracy or the People for the American Way, do they accept dark money?
Absolutely, Senator.
And is there some magical distinction between left-wing or socialist dark money and conservative dark money?
None at all.
And when the left-wing dark money organizations spend money in judicial nomination fights, What do they do, and is it any different than what the conservative organizations are doing?
None at all. I've got to demand justice spending $10 million to keep Ginsburg's seat vacant, for instance. News clip.
And now that Joe Biden is president, do we expect that these left-wing dark money groups will be working with Democratic senators and working to help confirm Democratic judges?
Every single day.
Arabella Advisors has been mentioned several times, and you write in your testimony that Politico has called this one of Arabella's nonprofits, the 1630 Fund, a massive dark money network. Why is that?
Well, on almost every scale, it registers. It's some of the top in lobbying, some of the top in fundraising, some of the top in TV ad buys against Republicans. In every possible way, it is a huge heavyweight.
There's also been a lot of coverage and hand-wringing about conservative groups that advocate judges who will be faithful to the Constitution. For example, the Washington Post wrote a long hit piece on my longtime friend Leonard Leo and his involvement with dark money. But curiously, the Washington Post never wrote about Demand Justice or other groups who were opposing President Trump's nominees using massive amounts of dark money. Why do you think that is? Do you think the Post simply wasn't aware that there was dark money on the other side?
Senator, I know for a fact that's not the reason. I know the lead author of that article, and as soon as the Leonard Leo article came out, I wrote him and said, hey, very interesting piece, but you know, there's a huge network on the other side, so you're going to tell the other side, right? Talk about that, and because they use more opaque funding methods for what they're doing. And I sent him my research, and you know, I think I got a yeah, someday maybe, but that's been years, no interest.
So the Post didn't cover it at all. All right, final question for Mr. Jealous. Senator Whitehouse has invited you here to make the case for transparency, and maybe this hearing is a good place to start. People for the American Way is a 501c4 that doesn't have to disclose its donors. In the interest of disclosure and transparency, which you're calling for, which Senator Whitehouse is calling for, will you today tell this committee your top 5 donors and how much they've contributed?
Yeah, would be happy to disclose that. Absolutely. Don't have it on me. Would be happy to disclose that. Would be happier, Senator Cruz, if you would commit to work with us to figure out how we finally build bipartisan agreement. You say that there's more dark money on the left, and it would seem to be in your best interest to actually help us champion transparency.
Well, then perhaps we have an agreement, number one, to get disclosure, and number two, if we can work together on the Super PAC Elimination Act, that would be a major bipartisan accomplishment. Thank you, Mr. Chairman.
Thank you, Senator Cruz. Before we conclude, I want to give both Ms. Graves and Mr. Jealous a chance to comment on what Mr. Walter has said in his testimony about their organizations. He mentions each of their organizations specifically, and I think it would be fair for them to have the chance to reply whether his comparisons you believe to be well-founded. Let me start with Ms. Graves.
Thank you, Chairman. You know, I think that there's a lot I disagree with in the statement by Mr. Walter, and I disagree with the characterization of the funding that CMD has received. I think that what Congress has done in H.R. 1 is draw some very important lines. For example, if groups are spending $10,000 to influence a judicial nomination, they would need to disclose all donors who gave $10,000 or more. I think those are good, and they're low thresholds, but they're, you know, significant thresholds, and that is the type of thing that, you know, does not apply to the work that the center does. But also, I think that, you know, the important thing from my perspective is that what I've said on behalf of the Center for Media Democracy and on behalf of others, you know, others out there who are concerned about this, is that it doesn't matter whether Scott Walter is right or wrong. I think he is incorrect in numerous ways. But what matters is that if we had this disclosure, we would all know definitively the answers to those questions. And as Senator Hirono said, quite frankly, the only members of Congress who are supporting this kind of disclosure in H.R. 1, in the Disclose Act, in the travel bill that you propose are Democrats. And that's a shame because, quite frankly, this should not be a partisan issue. Everyone should be in favor of this kind of transparency. And the effort to try to command that a particular group like People for the American Way on instantly disclose their donors when there's not the same parity, is sort of a way to have a show, but not to actually do anything to embrace and support laws that would level the playing field for everyone. And so the Center for Media and Democracy favors the measures that you've supported because they would apply to all the groups equally who engage in that activity. I also would say, Senator, that as a granddaughter of an immigrant who fled not one but two communist revolutions, I take personal issue with Senator Cruz's efforts to cast a smear across progressive funders by calling them socialist or implicitly communist. It's not the type of smear that I think we should tolerate in Congress.
Mr. Jealous, I don't know if there's anything you would care to add about Mr. Walter's characterization of your organization. You've had a chance to do that a bit already, so I don't know if you'd care. If not,
Yes, thank you, Senator Whitehouse. First, let me just invite Mr. Walter to take the same challenge from Senator Cruz that I accepted, and to disclose the 5 top donors to his organization. We're happy to do it. Similarly, we are here because we believe that it's time for every group to just be clear about who their donors are, to end this kind of throw the rock and hide the hand approach to politics in our country. It's what 70% of the people of our country want. And so it's time for there to be bilateral disarmament. The hypocrisy that you see from the right is they claim that there's more dark money on the left, and yet they refuse to be transparent. Well, it would seem if the first were true, then the second would be a no-brainer. I've spent a lot of my career working with Republicans to forge bipartisan agreement on criminal justice reform. I do know that bipartisan agreements are possible. It does seem that it's time for that. And an easy place for Mr. Walter would be to simply accept the same challenge I did from Senator Cruz and agree to disclose his top 5 donors.
thanks, Mr. Jealous. Professor Klarman, if I could ask you a last question in my time. Professor Adler suggested that there was, to characterize his testimony, there was really no partisan or pro-corporate signal that could be taken out of the Supreme Court's decisions. It was just, there's no signal in the noise, basically. We've looked at 80 partisan 5-4 decisions, which seems like a lot of partisan 5-4 decisions from a court that presumably should have an interest in, for its own sake, putting out decisions that have the broadest possible constituency within the court. And in those 85-4 decisions that we chronicled, every single one was a victory for big Republican donor interests, kind of 80-0. And that seemed to me like a pretty powerful signal out of the noise. Would you care to comment on what you think the basis is for detecting some pro-corporate signal out of the Roberts Court?
Look, it doesn't make a lot of sense to add up the total number of decisions. It makes sense to look at the most important decisions and whether those are decisions that are favorable to the Chamber of Commerce agenda. The Supreme Court has rewritten the law of class actions. The Supreme Court has invented new rationales to protect corporate speech under the First Amendment. The Supreme Court has made it more difficult under the First Amendment for public sector unions to operate. The Supreme Court has enforced agreements to not go to court, but rather to arbitrate disputes. These are big decisions. These are often issues where the Chamber of Commerce has been struggling politically to get its agenda enacted, for example, with reform of class actions or punitive damages reforms, and they've often been unsuccessful politically at getting their reform agenda, and then the Republican justices on the court have come along and given them what they sought by reinterpreting federal rules or reinterpreting statutes or creating new interpretations of the First Amendment. That's true with the corporate agenda. It's true more generally with the agenda of the Republican Party. If the issue is abortion or gun control, if the issue is campaign finance reform, if the issue is race-based affirmative action, if the issue is the Voting Rights Act, on all of these big issues, the Republican Party gets what it wants from today's Republican justices. I don't think that's because the justices are bought. I think that's because they've been very careful to select justices whose lives intertwined with the Republican Party. They often served in earlier justice departments. They've been vetted by the Federalist Society now for essentially their entirety of their lives. These people they're trying to promote people onto the court who they're pretty confident think about the world the same way they do. I don't think that's insidious. I think that's, Democrats also try to put people on the Supreme Court to do the things that they want them to do. It just turns out that the court's been captured by the Republican Party owing to a bunch of systematic Democratic defects in our political system. So even if Democrats win 7 of the 8 popular votes in presidential elections, even if today's 50 Democratic senators represent 40 million more people than today's 50 Republican senators, you still get a conservative court, indeed the most conservative court in the last 70 or 80 years. So I don't think it's a question of the justices being bought. I think it's a question of them being both ideologically in line with the Republican Party and naturally empathetic to the partisan interests of the Republican Party.
Well, let me, as the last questioner, conclude by thanking all of the witnesses for their participation. Let me also thank my ranking member for his patience and participation, and all of the members who have appeared during the course of the hearing. This was one of the livelier hearings that I've had the pleasure to be at, and I hope that it begins some of the kind of conversations for which the Senate is famous. If I had to use an analogy to my colleagues, I would use the analogy of a football game in which, under the rules, the football players have been allowed to bring a baseball bat out onto the field and wail away at the members of the other team. And we have the chance to actually get rid of that rule, that the baseball bats have to go to the baseball field and used to hit baseballs instead of on the football field and used to hit other players. But while that's the rule, to ask one team to say, well, if you were serious about changing the rule, you'd put down your baseball bats and let us wail on you undefended. Makes no sense at all. Makes no practical political sense at all. So I think I'm sorry, Senator Blumenthal has returned. I'll recognize Senator Blumenthal. My apologies. But I think you get the idea that if we're trying to fix the rule, let's fix it for everybody. And people play that about as much fun as politics is to watch right now. Senator Blumenthal, I'm sorry.
Thank you, Mr. Chairman. And I really...
And then we'll conclude, and I thank the witnesses again.
I very much appreciate your recognizing me, even though I'm not formally a member of the subcommittee. I think this is one of the most important subcommittees that we have on the Judiciary Committee, and my hope is that maybe we can have some bipartisan agreement, at least on the need for more judges in our federal system. And I see gathered here some pretty able litigators in absentia and present who know that the lower courts simply haven't grown to meet the needs of the American people. Anybody who has talked to litigators recently in almost any part of the state, particularly the parts of our country that have grown in population, know that the caseload over the last several years has grown by 20, 30, 40%. In this same period, the United States population has grown by 33%, and the courts simply haven't kept pace. I'm not going to keep all of us here to go over the statistics. They are abundant. My hope is that we can put more people on the bench by creating more judgeships that will better meet the needs of the American people. And I hope also that lower courts can be made to look more like the people of America. Right now, they are 80% white, 73% male. There's a lot of talent out there, both sides of the aisle, that could be put on the bench, and we need more diversity to reflect not only what the American people look like, but what the American people think like. And I hope that we can also move together in bipartisan fashion to achieve more diversity. I have a couple of quick questions, but I want to thank the chairman for focusing on the issue of dark money because it is such a pressing and important topic. It degrades and demeans the process that we hold dear in supposedly objective and independent appointment of federal judges at every level, most especially in the Supreme Court. I would like to ask all of the witnesses, yes or no, do you support stronger disclosure laws across the board, stronger disclosure laws relating to contribution?
Yes, Senator, I do.
Yes, absolutely.
Mr.
Anyone
Giles?
else?
Senator, I stand with the NAACP in 1958 and the NAACP today and oppose such efforts.
Professor Adler.
I think it depends on the details, but I certainly think that there are types of disclosure that are acceptable and there are types that go too far.
Thank you. Mr. Graves, we've heard some testimony today about dark money on the left being as large as on the right. Your testimony persuasively disagrees with that view. Could you expand on that contention?
Yes, Senator, I would love to, because I think that, there's an effort to create a false equivalency in lots of ways, or even a false portrait of what's been happening. What we know from the facts is that over the past 4 years, the president outsourced the pre-selection of judges to Leonard Leo. And as a result of that outsourcing, the Supreme Court and the lower courts have become stacked with Federal Society lawyers and now judges. We know that Leonard Leo has helped marshal millions and millions of dollars to both get those individuals nominated or supported, and then to get them confirmed. That is a particular role that's singular in the form of his person playing that role. No one on the left plays that role. Then if you look at the amicus briefs, what you see is a flotilla, as Senator Whitehouse has described, of some of these same groups that were active in getting those judges on the bench, the Supreme Court justices on the bench, then coming to the court to ask them to rule in their favor. If you look at that Rose Garden ceremony with Amy Coney Barrett, and you look at each of the groups that was out there in the audience at the announcement of her nomination, group after group after group then spent money after going there to celebrate her nomination and meeting her, and perhaps meeting her before then. They spent money to get her confirmed. Many of those groups now have cases that are coming up to the Supreme Court that she will rule on. They helped secure her confirmation, in part because they invested that money because they believe that she will rule in their favor. They're looking for return on investment. That's part of what Leonard Leo said in my interpretation of it when he told the Council of National Policy that because of these appointments, America is at the precipice of reversing nearly a century of law, of going back to the type of judicial activism or change in the law that we haven't seen since before the New Deal. And so I think it's quite clear that there's no equivalent to that that's happening on the left. That is a particular, unique, and I think very serious flaw in what's been allowed, and the fact that Mr. Leo, who I'm not alleging has done anything legally wrong, was not required by the law to file any financial disclosures for his income while he played that special and unique role. I think these are all signs of serious problems in the nomination process, in the amicus process, and in the effort to capture our courts and roll back decades of law.
Thanks, Ms.
Senator
Graves.
Blumenthal, thank you.
Thank you very much.
The hearing is now concluded. For the record, Senator Blumenthal is more than welcome because under the Judiciary Committee's rules, members of the committee are welcome at any subcommittee hearing. So his presence here was both welcome and well within our rules. And again, I thank the witnesses and my ranking member. The final step is to put into the record without objection a great number of letters from groups that have sent in their views, as well as our captured courts reports that have been so much a subject of the conversation.
Mr. Chairman, I'd like to put something in the record here
Without
as
objection.
well. Thank you, sir. Good job, Shelley.